The clerk will open the court.
May it please the court, Mr. Meshes will present argument for relator. Relator has reserved 5 minutes for rebuttal.
Mr. Meshes.
May it please the court, this sovereign immunity case turns on legislative choices. The legislature knows how to make ERCOT a governmental entity. It knows how to supply it with tax dollars. And it most certainly knows how to issue an expressed legislative directive that ERCOT enjoys sovereign immunity. But it did none of those things. ERCOT is thus asking this court to do what the legislature chose not to do and blanket ERCOT in the state's sovereign immunity. The court in this case should honor the legislature's intent and hold that ERCOT, a nonprofit corporation that receives no tax money, is not immune. And that is particularly true here because the government did not direct or control any of the conduct at issue. So this morning I will address 2 points. First, the Court of Appeals erroneous immunity holding, and then turn to ERCOT's alternative exclusive jurisdiction argument, which, like the immunity argument, is foreclosed by the statutory text. So let me begin with the immunity issue, and I want to focus on 3 points. First is the arm of the state standard. Second are the purposes of immunity, and finally the control inquiry.
Mr. Meshes, before you get too far into that, just a preliminary question. I couldn't find, actually I probably could have if I'd gone on our electronic access website, but in the record, what's the status of your direct appeal of the trial court's final judgment to the Court of Appeals?
Justice Boyd, the status of that case is it was argued last October and then subsequently abated by the Court of Appeals pending this court's disposition of the pending proceedings.
Okay, thank you.
You're welcome. In terms of the arm of the state inquiry, the point here is there are no statutory indicia that the legislature intended ERCOT would be an arm of the state simply because it was certified as the independent organization. It is actually just the opposite. The legislature denied ERCOT governmental status and reinforced its fundamentally private nature. Here is what, if you look at the exhibits that were provided yesterday with the statute, you can go through all of them and you will not see any of the following: a designation or characterization of ERCOT as a governmental entity of any kind, as a governmental unit, board, agency, anything. There's no indication in that statute that there was an effort by the legislature to fund ERCOT with tax dollars, subject it to the legislative appropriation process, or
excuse me, but didn't the legislature give the entity administrative powers, including the ability to impose penalties?
So the regulatory power question you're referring to, Justice Lehrman, is the ERCOT's argument that it was delegated rulemaking authority. Right. Several responses to that. First of all, that power was expressly circumscribed by the legislature's intent, which says that the PUC has input, oversight, with respect to those rulemakings. In addition to that, in the PUC brief and the TIEC brief, it's crystal clear that the PUC has to have input into those protocols. So what that means as a fundamental matter here is that ERCOT is not a private legislature. The PUC is the entity that makes the law. And in fact, in the cases interpreting protocols, what happens is the courts are deferring to PUC interpretations of those rules, and they get folded in to the jurisprudence on those questions. So
doesn't that undercut your argument that there is no governmental oversight and it's not an arm of the government if the PUC is the ultimate arbiter of regulations that ERCOT adopts and really overall control over their budget with the ability to veto any particular expenditure? So that's a little bit different than the Rita's case.
So a few points about the oversight. Our position is it is correct that ERCOT is subject to PUC oversight, but that the inquiry here is to look at the nature of the entity and does the statute change the nature of ERCOT. And our position about that is no. And in terms of the oversight that exists, it really establishes a regulatory relationship between these two entities and empowers the PUC to exercise that oversight, not ERCOT. So with respect to some of the court's prior cases, I would just note Rosenberg is probably the most helpful in this regard, because in footnote 44, the majority opinion notes that the Rosenberg entity was subject to budgetary control by the city, by the political subdivision that formed it. There were tax dollars that flowed into it, into the entity. And with respect to the EDC, the Economic Development Corporation, in that case, that this political subdivision had control of the projects. So the oversight level is not that much different, and it doesn't answer what the fundamental question is, I think, that Ben Bolt and the related cases ask, which is, what is the nature of this entity? There's no governmental entity status, there's no tax dollars, and there's no authorization, for example, for the governor or the PUC to appoint the board. And unlike the court's decision in Amex Properties, the legislature did not confer immunity on ERCOT. So every marker this court has looked at in its recent cases is completely missing here. And
so turning to the governance the governance question that you brought up, does the PUC have the ability to approve, amend, alter the bylaws of ERCOT? And does it have the ability to say, if ERCOT decides they want to remove a board member, the PUC can say, no, you can't. Is that right?
that is correct under the PUC administrative rules, but that is not a power that's given pursuant to the statute. And since this is a legislative inquiry, I think that is important. What the statute actually says is that the PUC has the opportunity for input, but at the end of the day, that the board, the bylaws are created by the ERCOT board itself, by the members. Remember, this is a membership company at its foundation, and a board that directs the day-to-day policy decisions. So the answer is yes with respect to the bylaws, but I will note with the board, even with the input authority that the PUC has, the PUC does not select those members. And in fact, they are directly elected by industry market segment groups, 6 market segment groups, 3 customer groups, and then those groups then select the independent members of the board. So there is a enormous gulf between the kind of control, for example, that the political subdivisions had with respect to the makeup of the board and the Rosenberg case and what we have here. Justice Guzman, I was about to ask a question a moment ago.
Well, if I might, I was going to ask you about the functions of ERCOT in terms of who dictates those functions. It seems like they exclusively, the PUC and PURA, and should we examine those? I mean, does it have any other role?
So the answer is that the general roles are spelled out by section 39.15A. That is true, and it's set forth in the statute. However, but that was also the case in the Incarnate Word case, where the police authority function was set out by statute. It was the case in Rosenberg, where the role of the Economic Development Corporation was set out by statute. So again, the question here is the nature of the entity. And then I would suggest that you should look past the simple fact that it's designated by statute to do certain functions, because here is the question. The question, is it a government function? And the answer to that is no. If you look at what the court said in Rosenberg about what is a governmental function, it asks the question, is it so definitively uniquely governmental that only a government would do it? And the answer to that is no. Prior to this statute, ERCOT was performing these exact functions. That's what they put forth in their application to be the independent system operator. That is true across the country. Other independent system operators and RTOs exist, and they are not governmental in nature. And at the highest level of generality, the legislature has expressly stated that operating and maintaining utility, even when it's done by a municipally owned utility, is not a governmental function.
But when they were acting, even prior to the statute, their function was really not that of a private entity. It was to coordinate so that all of this would work together. Isn't that correct?
It was a coordinating function, but that has always, Justice Lehrman, been a private responsibility and a private role. That's how ERCOT was organized before. the pure amendments came along, that's definitely true with respect to the other RTOs. It's a matter of history. That's
true. It's true. It was private in one sense, but in terms of the quasi-governmental function aspect, it seems that that's not correct, right?
I would respectfully disagree with that, Your Honor. And I think if you just look at the function that was actually at issue in this case, and that's important because here, what ERCOT did is it made representations about the marketplace, about the capacity for energy, the supply and demand, and all of that. That is not a governmental function. Sending information out to the marketplace is not a governmental function under any way of looking at it. And what is true is that operating utility, maintaining that utility has never been a governmental function. And if you look at the other RTOs, the other ISOs across the country, it is not done by a government and it is not a governmental function. In fact, the entire purpose of this regime was to de-governmentize it, to make it in the hands of the private sector. And this is not only a governmental function. And I think that is the test laid out in Rosenberg. And it makes perfect sense because here is really, I think, what your question gets to. If that is true, why did they not ask the PUC to do this job? Why did they not hand this responsibility over to another governmental agency? And I think because the legislature fundamentally did not view this as a governmental function in any respect.
Mr. Meshes, are some of ERCOT's members governmental entities or political subdivisions? And if so, do you have a sense of how many?
Yeah, so there are, I believe, municipal utilities. I want to confirm that they're a part of it, but of course that are members. But I think that the key point there, Justice Boyd, is that when those entities operate utilities, that is when they maintain their electrical wires and they operate those entities, they're not performing a governmental function pursuant to the Tort Claims Act. So I don't think that really changes the analysis. But really, the members themselves are largely industrial-owned utilities, generation companies, things of that nature, and they are the ones that pick the board. The ERCOT is, while it is certainly answerable to the PUC, and it is answerable in terms of the regulations and the statutes, it is directly answerable to its members who select the board. And ERCOT's answerable to its board, which is largely made up of the private sector, industry-focused approach.
Mr. Meshes, you mentioned that obviously the issue here is not arising out of the power to propose these guidelines that the PUC then adopts, but out of the report that ERCOT had issued. And so what do our cases tell us about how that plays into the immunity analysis, whether a entity has some factors some functions that could be considered governmental and others that may not be? How do we weigh that when the suit arises out of a function that doesn't seem governmental? Does Incarnate Word tell us that we have to look at control over the particular activity, or how do we parse that?
Right, and I think the answer to that is answered in two respects. Number one, the court's Benbolt standard focuses on, do you have the nature, purposes, and power of government in the discharge of a governmental function? And so I think using that language, the court could very much look at the specific conduct at issue. I think even though this is a case where it is clear that ERCOT is distancing itself from the derivative immunity theory, I do think the court's writing in GTEC is helpful in understanding that you can have final approval by a governmental agency, veto power over certain decisions like the Lenore case discussed in the court's opinion there, and still have considerable, indeed independent discretion over the matters at hand. And I think what this points to, Justice Busby, this independent discretion point, it really undercuts the idea that the ERCOT is simply an adjunct of the PUC, as ERCOT has said, or it is under the thumb in every possible respect, because the fact of the matter is here, there is no contest of the following point, that ERCOT had independent discretion, and the PUC in fact documented that in a memo describing what happened with respect to the CDRs. And it's even true today under the new CDR protocols, which leave to the ERCOT the form and content of the CDRs. And so in the remaining moments, I would just make one point about the purposes of immunity, because there is no fiscal connection. There is no financial connection between the state and ERCOT at all. The nature and purposes of immunity are not implicated, and there is simply no worry about the public fisc.
What if there would be an increase in fees because of a judgment like this? What about that?
Well, I do not think that raises a separation of powers problem for two reasons, Justice Lerman. Number one, it has no impact on the legislature's prerogative to discretionarily allocate tax dollars because it's not subject to the legislative process. Mr. Chief Justice, can I conclude my answer to this question? Okay, and second is that power is not in any way interfered with here. The PUC retains its authority to make decisions about whether a fee might need to be increased or not, and it still rests in its hands. And for these reasons, we ask the court to reverse the
If I may, Chief, I know you've still got rebuttal time, but you're going to be rebutting 20 minutes of argument. So in case we don't get to it, I just wanted to make sure you didn't get to the exclusive jurisdiction issue because we kept you on the first issue during your argument. But I just want confirmation, is it your position still that we should remand that issue to the Court of Appeals if we agree with you on sovereign immunity? Or do you now agree that since it's fully briefed, the court ought to go ahead and decide the exclusive jurisdiction issue?
It's the latter, Justice Boyd. We think it's a statutory interpretation case that's plainly before the court, and the clear legislative intent, just to close out the answer, is that the legislature did not intend for the PUC to have exclusive jurisdiction like it did in other provisions of PURE.
Any other questions? Thank you, Mr. Meshes. We'll hear from ERCOT.
May it please the court. The Texas electric grid, unique in the nation, is the fuel for the Texas economy, the source of the state's police power, the electricity that supplies every home and business, each hospital and traffic light, and every Zoom hearing. The legislature charged ERCOT with the essential duty to ensure that the system guards this public interest. I will focus primarily on sovereign immunity, and the Solicitor General's office will address exclusive jurisdiction. ERCOT is immune because its enabling statute, which is before you, we attach it as an exhibit, establishes the nature, purposes, and powers of an arm of state government. And we know this because ERCOT performs essential and exclusively governmental functions. ERCOT has rulemaking authority to perform that essential role. That's a sovereign power. ERCOT is part of the electric regulatory apparatus overseen by the PUC, created by PURA, which gives the PUC,
excuse me, Mr. Jefferson,
complete authority. Yes, Justice Lerman.
Let's say that we agree with you on that, but we look at the public fisc aspect, which of course we always informs our analysis in these types of cases, and there are no taxes. There are simply fees that could be increased, but that has nothing to do with the separation of the branches and who makes determinations about how fiscal matters are going to be dealt with. What's your response to that?
Well, ERCOT is funded with public money. It's through the system authorization fee. That fee is set by the Public Utility Commission. It's collected by the state of Texas. The Public Utility Commission has plenary authority over how ERCOT spends that money. If the PUC, and this is critical, if the PUC were to decertify ERCOT, which you'll see a provision in 39.151 for that decertification, ERCOT's assets don't stay with ERCOT. They are transferred to the successor organization. So those assets are not private, they are the state's. And revenue from the fee,
doesn't
just
that
like
show
general
that the fee doesn't that show that there wouldn't be an impact on the public fisc by a judgment against ERCOT in this case?
No, because it's not just the assets that are transferred, but the liabilities as well. The function, so the liability, and that's in the statute as well, the liability would transform to the successor organization. And so it would be crippled. It wouldn't be able to perform its essential governmental function. And that function is to protect our electric grid. And even more so, the revenue from that fee, unlike, or very much like general appropriation, pays for other state priorities and agencies. And we've named some of them in our pre-submission briefs. So for example, to combat the current COVID-19 crisis, the PUC needs to be able, just like we're doing now, to conduct its business remotely. ERCOT could not do that on its own. It had to get permission from the Public Utility Commission to do so, because Public Utility Commission governs all of its operations. But also the PUC created an electricity relief program. This is to help people who are harmed during this COVID situation. To do so, the PUC ordered ERCOT to provide up to $15 million to cover the program's upfront costs. This was not discretionary with the ERCOT. It was ordered by the PUC. This tells you that they have the power, the PUC, to overtake the entire budget. The collection of that
not
fee,
similar to what we had in Rosenberg?
well, no, but the collection of this fee is through state power, and through state power. And in Rosenberg, Your Honor, the statute prohibited the municipality from delegating any of its attributes of sovereignty to the Economic Development Corporation. In ERCOT's case, it is a fee that is used to ensure the grid, the reliability and the stability of the electric grid. That makes it a public asset. And because it's a public asset, that's why if there's a decertification, those assets are controlled by the PUC and transferred to a successor organization.
Mr. Jefferson, how do you respond to Relator's argument that ERCOT is, with some relatively minor distinctions, simply fulfilling the role it's always fulfilled as the organization that coordinates the grid and tries to maintain reliability, and that traditionally that was not a governmental function? It was, prior to 1999, completely private role, and its members are not governmental entities, with a few exceptions, and those that are governmental entities, the municipal utilities, are engaged in the system in a proprietary function, not a governmental function. And therefore, as Relator argues it, the whole system is by design proprietary and private, although highly regulated, not governmental.
Well, Panda has done this throughout this litigation to say that the ERCOT from the 1970s is the same as the ERCOT of today. In 1970, ERCOT was a completely voluntary membership organization, and it handled interconnectivity, but it had no authority over its members. It was only a coordinating body. With Senate Bill 7, there was a huge transformation of the way electricity is generated and distributed in the state. And the interconnected utilities had to unbundle their generation, transmission, and distribution and retail functions. And so the idea was to deregulate the industry, and consumer prices would now be set by the market. But at the same time, the legislature said the grid was still in need of regulation, as was the newly created energy market. It declared that an independent organization was essential to regulate aspects of this electricity system. And it said in the legislation.
My question focuses on this electricity system, the nature of this electricity system you just referred to. So here in Austin, not too far away, some residents get their electricity from, I think, Blue Bonnet Co-op or whatever it's called, a non-governmental private entity. I'm in the city of Austin. I get it from the city of Austin, Austin Utilities. But in neither event, as I understand it, are either of those entities engaged in a governmental function. They both have highly regulated responsibilities to ensure the reliability of the electricity for me and my neighbors, but in neither case is that a governmental function. And if that's the case, then how could the role of ERCOT in coordinating the efforts of all of those retail entities as well as the other two levels, what transforms that into a governmental function when even at the retail level, it's municipalities engaged only in proprietary functions?
I think you have to go to the text of the statute again. The essential organization, ERCOT, was created to protect the public interest. That is its mission. It's an overriding mission to ensure the reliability of the electric market for everybody, for the Panda members, but also for consumers, for everyone that needs lights and power. As the Sunset Commission wrote in 2011, and I'm quoting here from its report, the legislature has transitioned ERCOT from an industry group that managed the exchange of power among monopoly electric companies into a public purpose agency. So the essential centerpiece of this new paradigm is for ERCOT to perform functions that are governmental, specifically to ensure the reliability and adequacy of the grid, that all buyers and sellers of electricity can access the transmission and distribution of the system on a non-discriminatory term, and that the market functions properly. And this means that ERCOT performs critical functions like coordinating and scheduling power by market participants and ensure the matching of generation and consumption at all times. It's the reason why Texas doesn't have the problems that California suffers with the brownouts, because the interplay between ERCOT and the PUC has stabilized our electric grid. And ERCOT
Mr. Jefferson,
yes.
You said in contrasting the ERCOT of the 1970s with the ERCOT of today that the ERCOT of the 1970s was a voluntary membership organization. Is membership in ERCOT voluntary today or not voluntary?
It's prescribed by statute again. So the ERCOT, it's mandatory because it's created by the legislature. And so ERCOT functions as an arm of the state by direct authority of the legislature. It can't go out of existence without legislative changes or modifications. And if ERCOT were to go away today, it has to have a successor organization in order to maintain the stability of the market. That's how it's designed.
Mr. Jefferson,
yes.
If because the particular conduct here doesn't arise out of the mandatory nature of the membership or some of the other or any regulations that ERCOT may have mentioned, I'll ask you the same question I asked Mr. Meshes about how do we deal with that, and does Incarnate Word say that we should look to control over the particular regulated activity, the particular activity that's at issue? And if we do that, what weight do we give to the fact that the legislature was silent on whether ERCOT should have immunity, unlike in Amex properties?
So there are two questions there. The first, I think the premise is slightly off, Justice Busby, in that ERCOT was ordered by the Public Utility Commission to issue these CDRs, these reports about capacity. So it is performing, as I mentioned, a public function at the direction, at the command of the Public Utility Commission.
ERCOT doesn't control the content, is that right?
It doesn't write the report, but it compels the report. It compels ERCOT to do the action. And everything that ERCOT does is to fulfill the PUC's command to ensure reliability. And one way to ensure reliability of the system is to have forecasts of potential power needs.
Mr. Jefferson, if I might, before you leave that point, what is the level of discretion, though, that ERCOT exercises in the CDRs? I think the council spoke about a memo that considered that it was ERCOT's discretion, not necessarily a particular.
So it is again, it's a statutory duty. The ERCOT is directly responsible to the commission. I'm reading from section 39.151. The commission has complete authority over the budget and operations as necessary to ensure that it fulfills its duties. And so if the Public Utility Commission has a problem with the manner in which these reports are generated, the PUC has complete authority to change it, to order them to do it differently. So the discretion, I'm sorry, just a Guzman.
Do they exercise independent discretion?
They do. We are a product of ERCOT's commands. We do our work, very well, I believe. But if there's any question about it, the PUC has complete authority to change the way we're doing this. Yes.
Regulations also say that that any action the PUC might take against ERCOT should not be read to preclude any form of civil relief that might be available under federal or state law. That's in a regulation, I believe. And so if the PUC doesn't think that anything they may do precludes any other form of relief, why should we interpret a silent statute to do that?
It doesn't preclude any relief that's available, but if immunity governs as we think it does, that there is no option for relief for a person in Panda's appointed posture. And the reason is because the impact of a judgment on electricity in Texas, diverting, this is a quote from Amex that I think applies here. Diverting the charter school funds in Amex to defend lawsuits would quote, affect the state's provision of public education and reallocate dollars from the legislature's designated purpose. Here, the legislature's designated purpose is for ERCOT to use all of its talents and powers to ensure the reliability of the electric grid for the benefit of the economy, for the benefit of the police powers and the health and welfare of the citizens of Texas.
With apologies, Chief, if I can just ask two very quick questions. First, Mr. Jefferson, does ERCOT claim to be engaged in any of its activities pursuant to a contract with the government? In other words, does it claim to be a government contractor within its role?
No.
So if Brown and Gay analysis is limited to government contractors, it would not apply here.
I think it does not apply for that reason.
Okay. And my last question is, what are we supposed to do with the mootness and advisory opinion arguments in light of the final judgment that was entered by the trial court? Do we just conveniently ignore the jurisdictional issues because it's more efficient to answer the questions here?
I think this is something that Mr. Meshes will need to answer, but let me just tell you why we're in the posture we're in. When the Court of Appeals issued its opinion, it gave the trial court, I think, 30 days in which to.
I'm familiar with why, and you agreed to a stay and they didn't ask for it, but what would our mandate in this particular consolidated proceeding actually do?
There's a legal question that is fully briefed, and that is before the court. So the court could, if in its discretion, refuse to answer that question and wait until it comes back up again. Right now, the Dallas Court of Appeals has abated its proceedings in deference to this court. Or the court could answer the question, and I believe that both parties are seeking an answer today. We have briefed it.
I think you are too. Yeah, I think you are too, and I think the court has indicated its desire to decide the issues here, but we all know we can't create jurisdiction by consent and agreement. And I'm just wondering what your position is in terms of, not for this case, certainly more efficient to decide it here, but can we?
The court can. The court has has the last word on Texas law. And the court, if I were the court and this were in the same procedural posture, I would answer the questions. Before the court, they've been briefed. It would be a waste of resources, both today's, but also this whole process, not to give the parties the answer to these vital questions of Texas law.
Any other questions? Thank you, Mr. Jefferson. We'll hear from the PUC.
Thank you, Mr. Chief Justice, and may it please the court. As Mr. Jefferson indicated, I'd like to focus my time on exclusive jurisdiction. But just to start, Justice Boyd, by addressing your question, all of the issues here we're talking about are jurisdictional, and we have, I think, at least 2 courts of appeals that have abated their proceedings awaiting for the answers from this court. So the court can address the jurisdictional questions presented here. The heart of the exclusive jurisdiction grant is in section 39.151D of the Utilities Code. And if I could just highlight some of the language there, and Mr. Jefferson has highlighted some of this already. But the first phrase I would point to is complete authority. The commission has complete authority over ERCOT. That's what the legislature said. If that's the case, then a court exercising authority would interfere with that commission authority. ERCOT is directly responsible and accountable to the commission. It can't be both directly accountable to the commission and accountable to a court. And I think we're seeing here what the legislature often does. It takes a category of disputes and puts it before the agency that has the specialized knowledge to deal with that. And we see that also looking a little further in subsection D as to the remedial powers of the commission. The commission is empowered to take any action it deems appropriate. The legislature used the word including to provide a couple of examples, but not to foreclose the commission from imposing other relief that it considers appropriate, taking into account the effect that relief would have on the electric grid and the very important functions that Mr. Jefferson highlighted that ERCOT performs.
Mr. Davis, do you agree?
The language in D4 number 6 that the commission may resolve disputes between an affected person and an independent organization. Doesn't that may suggest that the PUC's role is discretionary rather than mandatory? And then further, what do we do with the PUC regulation that says it doesn't preclude any other remedies that are available, civil relief that may be available under federal or state law?
Sure. So let me address the affected person and make 2 points about that. The first is that the parties have disputed whether Panda meets the definition of an affected person. I don't think the court really needs to decide that, and here's why. There's no dispute that Panda qualifies as an affected entity under the commission's rules and could take this dispute before the commission and the commission would resolve it. And Panda hasn't challenged that rule as in excess of the agency's statutory authority. And I think the reason for that goes back to subsection D. The commission could sua sponte open any investigation into ERCOT that it wanted. It wouldn't make sense to strip it of that power simply because of the identity of the person who brought the complaint. And then the second point is that I would point to this court's decision in Encore versus Chaparral at pages 140 to 141. That addresses another may provision that was in section 17.157 of the code. And the court there said, that statute is just laying out some of the powers that the commission has. That doesn't detract from the exclusive jurisdiction that we see from the broader statutory context. And so that passage controls the analysis of subsection D4 here. Now, of course, in Chaparral and in many of the cases, there was also an express grant of exclusive jurisdiction. We don't have that here, and Panda says that is a problem for our position. But that's not the case. We know since this court's decision in Subaru and every other case that's come down, that there are two independent paths to exclusive jurisdiction. One is an express grant, but the other is a pervasive regulatory scheme of the kind we see here in subsection D. And I'm
Mr.
sorry.
Davis, do you agree with Mr. Meshes that the board of ERCOT is independently selected and independently governed so that it could determine its own bylaws independent of the PUC?
Well, I think maybe as an initial matter, but everything ERCOT does, all of its operations, that's a very broad term, is subject to the commission oversight. I see my time has expired.
You may finish your answer.
That's really it. Maybe in the first instance, ERCOT can do all sorts of things, but it's all subject to the authority of the commission. And again, in our view, that puts it squarely within the exclusive jurisdiction of the commission, and that's the easiest way to resolve this case.
Any other questions? Thank you, Mr. Davis. Mr. Meshes, I believe you have 5 minutes remaining.
Thank you, Mr. Chief Justice. I'm going to cover 3 points in rebuttal. 1, the governmental function. 2, the independence issue. And 3, exclusive jurisdiction. Starting with the governmental function.
I'd like you to address, if you could, the money. ERCOT argues that this is ERCOT's funded by a tax or a fee imposed on customers, and that money is essentially state property. What's your response to that?
Yeah, that could not be more wrong, Justice Blacklock. For starters, not a single penny of the administration fee ever hits the state coffers. The state would never have to pay a judgment. ERCOT, in fact, has insurance for the very kinds of claims that are issued here. There is simply no flow of funds between the state and ERCOT. And I think that disposes of the public fisc issue. Whatever label they put on it, the bottom line is the legislature is never having been called on to make an allocation. Now,
but you don't disagree that that ERCOT is funded by a mandatory fee that's imposed by the legislature, that akin to a government tax?
I don't think it's akin to a government tax, actually, Justice Blacklock. Here's how I think the right analogy should look. It's just like the investor-owned utilities that charge a rate, because in that case, the entity cannot collect that rate, cannot charge that rate without government approval. And in fact, that is exactly what ERCOT told the Austin Court of Appeals on Highway 3, that it's akin to a regulatory rate function. It's just like in the insurance context, the telecom utility context, and many others. So I don't think it's a fee at all. It never hits the state coffers. In terms of the government function, I just have to correct something that is very wrong about what we heard just a moment ago. The members of ERCOT, it's totally voluntary. You decide if you want to enter the marketplace, you sign a voluntary market participation agreement. That agreement does not say a word about ERCOT being immune, about it being a governmental entity at all. And I think it's important to understand what ERCOT was doing immediately before Senate Bill 7, because what Mr. Jefferson pointed to is what was happening in the 1970s. That is not the comparator we're asking the court to use. We're saying, look at ERCOT's application in 2000 to become the independent organization. They said they were doing the reliability function up until that point as a private entity. And that underscores a really important statutory point here, Your Honors, which is that the legislature was not operating under a blank slate. It was coming to ERCOT as a pre-existing private entity doing these exact functions. And if it wanted this entity to be immune, it would have done the things you talked about in Amex. It would have.
But what do you say about the argument that this entire purpose of this is to protect the public electricity grid, and that prevents major problems like brownouts here?
That is right, but that's exactly what ERCOT was doing before. That's exactly what the other independent system operators do all across the country, and they're not private in nature.
I don't think that the fact that it did it previously and the statute didn't authorize it really impacts the fact that it is serving that public interest, which is a huge public interest. And surely that's a consideration that we need to take into account in the analysis.
What I would say is I think that question is answered by the court's decision in Rosenberg, where the court noted that public function does not determine the nature of the entity. You have to look at the entity itself. And here it's not a governmental function in its traditional sense, in its current sense, and certainly not with respect to the conduct that is issued here. And so let me turn to the second point about independent discretion, because there is no dispute. It's in mandamus record 8/3065 that there was independent discretion, and that this isn't the issue. The conduct at issue here is not governmental. It is market facing, is to induce investment into the marketplace. And I would say the board here, the board's role here, Justice Belanger, your question about independence, if you compare it to Rosenberg, where the city got to pick the board and fire the board, totally different. Finally, I want to cover exclusive jurisdictions. We heard again, their argument really rests on an administrative substantive rule by the PUC, but the answer to this question is based on the statute. You cannot imply jurisdiction based on oversight. There are three key legislative decisions that lead to the, we think, quite obvious conclusion that there's no exclusive jurisdiction here. And that is because the legislature directly spoke to the question in D46 in a permissive way. And there's no dispute that Panda is not an affected person covered by that provision. And if you look at the court's jurisprudence in this area, you see, one, that it's obvious the legislature knows how to convey exclusive jurisdiction in the context of PURA. Second, there is no such provision here. And third, D46, that was the legislature's attempt to address the issue, and it did not confer exclusive jurisdiction. It's an oversight provision, and that's it. And for those reasons, we ask the court to reverse the Court of Appeals decision.
Any other questions?
Yeah, Chief, I have one. Counsel, you addressed Justice Blacklock's questions on the fees, but what about the assets and liabilities in the event of the dissolution of ERCOT?
Yeah, yes, Your Honor. So on both points, on the assets and liability, how that works is just a matter of the legislature mandate that the PUC has that oversight role. But what the asset point underscores in our view is that those are actually ERCOT's assets, not the state's. Why is that? Just look at the financial statements that the parties have cited to that call them. They're on the books of ERCOT's assets, on the asset ledger. The dollars themselves never flow to the state. And the fact of the matter is that there's a statutory provision that requires the transfer, I think demonstrates that they are not in fact property of the state or the PUC. And I don't think the usurpation or transfer provisions impact the analysis, and they're not part of the legislative appropriations process as well.
Any other questions? Thank you, Mr. Messers. The case is submitted and the court will take another brief recess.